Good afternoon, and thank you for joining me. I'm Joshua Curtis. I'm an attorney here at Beresford Booth. I'm going to be talking on a estate planning topic today. I'm talking about testamentary trusts and revocable living trusts and how they differ, what advantages one might have over another, and in what circumstances you might want to use them. So we'll jump right in here. All right. So first of all, some just to get some definitions out of the way here. Trust is uh, a legal entity where a trustee is the person that's responsible for holding the assets, investing assets, distributing assets. The trustor is the person who created the trust, and they create the trust for a beneficiary. So the trustor creates the trust, the trustee manages the assets of the trust, and they manage those assets for the beneficiaries. And then if the trustee becomes incapacitated, they pass away, or they resign, then a successor trustee takes over. And then same thing with beneficiaries. It can either be designed that there will be successor beneficiaries, or sometimes if a person passes away before their share is completely distributed to them, the trust would say where that money goes to a successor beneficiary. All right, so we're going to talk about testamentary trusts first. So, a testamentary trust is a trust that's created by someone's will. So it doesn't get created at the time they're doing their estate planning. It gets created after they pass away. And the trust is actually created then by the personal representative of the estate during a probate. So the executor or personal representative opens the probate, and as part of the probate, dealing with assets and creditors and this and that, they create this trust and then fund the trust. And here, the next slide is how is a testamentary trust funded? So it's funded with assets of the estate, and this can either be like a percentage of the whole, 20% of my residual estate goes to John Doe as trustee for Jane Doe, as example. Or it can be specific assets. Um, it could be, a home. It can be cash. It could be, all types of different assets. And, the trustee is able to sell that asset, buy a different asset, do things that they need to do. But typically, you try to fund the trust with assets that are going to be the most useful for the trustee to deal with and to achieve the goals of the trust. All right, what's the purpose of a testamentary trust? So, oftentimes, well, there's kind of two main purposes that people end up using testamentary trust for. So, one, probably the most common is for minor children. So, you're not allowed to leave really any significant assets to a minor in a will, um, but you can leave it in trust for that minor. So, typically if I'm doing estate planning for someone with minor children, then we would have a, provision that, if any of my kids are under a certain age and I pick 25 kind of as a starting point, and then if the client wants to do higher or lower, we do a different number. But if any of my kids are 25 years or younger, then this trust gets created. And then the assets go to, John Doe as trustee for my children. And then there's instructions in that, in the will on how the trustee can distribute assets. At what point do they have to distribute all of the remainder of the assets and close the trust? There's provisions, if one of the children were to pass away before their share was fully distributed, um, how it would probably go to their kids, which is kind of the most typical um, uh, provision that people have in their wills for providing for their children. And then the second most common is for a surviving spouse for estate tax reasons. So in Washington State, just I believe yesterday, or this week at least, the governor signed a new bill that changes the Washington State exempt amount for estate tax to $3 million. So if you have over $3 million for a married couple, then if it all consolidates into one person, then that person would have the state tax that would be due at Washington state level. So it's possible to use a testamentary trust to break the estate into two pieces when the first spouse dies. So you can use the exemption from both spouses. So, you could essentially shield up to $6 million with a $3 million per person estate tax exemption. And that kind of looks one of two ways. Either it's built in where it will split into two pieces, or it's built in it's called a disclaimer trust. It's built in where the surviving spouse can decide if they're going to trigger creation of that trust by doing a disclaimer, which is a technical thing that they have to do. It has to be done within 9 months of the date of death. There's some other rules about disclaimers. But if they properly disclaim assets, then those assets go into the trust, and the surviving spouse is usually the beneficiary. Well, the surviving spouse is the beneficiary. Surviving spouse is also usually the trustee. So the surviving spouse manages the assets in the trust for themselves, and then when they die, it goes probably to the children. But wherever the first person to die, wherever they said it goes after the spouse dies, that's where it goes. So but the surviving spouse gets to use it for the rest of their lifetime. So it has uh, not much effect on the quality of life for the surviving spouse, but a big impact on splitting that estate into two pieces. So both estate tax exempt amounts get to be used. Similar to that is dealing with blended families. So, typically my clients, if he has kids and she has kids, they both want their spouse to have, a similar quality of life for the rest of their life. So often they would say, all of my separate property assets that I had from before the marriage and any, my half of community property assets, I put into a trust for my spouse. But then when my spouse dies, it goes to my kids, and then the surviving spouse can have their half go to their kids. So it's a way to um, be able to make sure that something's going to each side of the family um, without having it go that way at the first death. So the surviving spouse can continue using the home, using the money, all of those things. Another one, this doesn't come up for me as often, but is a special needs trust. So, if someone has a child who has special needs, or I guess any beneficiary they're choosing to give money to in their will, they can create a special needs trust so that money is held under certain rules. So it doesn't, there's tax reasons and benefits reasons that it's held in a special needs trust. So a special needs trust can be created through someone's will, and that's a type of testamentary trust. And then the last one, at least in my examples here today, is that this, like any trust, gives you more control over your assets after you die. So typically in a will, it says I leave everything to my spouse. If my spouse has predeceased me, I leave everything equally to my kids. And that's just outright to the kids. They can, assuming that the kids are adults, they can take that money and spend it wisely, or they can take that money and not spend it wisely. Um, but sometimes clients, when they have a feeling that the wealth that they've acquired, they've worked hard to get, they're worried that their kid will not spend that wisely, or it could even be detrimental to the kid's health sometimes to receive a large chunk of money. They could choose to have it held in trust. So, someone else holds the money and has a set of rules that they have to follow that are set up by the parent in the will. And, it could be anything from distributing a certain amount of money each year, uh, doing a certain percentage each year so it ends over a certain number of years. So there's ways to, either have money just stretched out over a longer period of time, or give the trustee more discretion to distribute money for certain events. You could make someone hold their money until they retire. I mean, there's a lot of things that someone could do uh, to sort of direct their beneficiary on how they get to use that money. Uh, and oftentimes we think about it as sort of a safeguard against that money being wasted. All right, so now a revocable living trust. So a revocable living trust, there are a lot of different types of trusts. You know, there's a lot of different types of trusts that are created during a trustor's lifetime. But a revocable living trust is the most common that's used for estate planning. And the idea with a revocable living trust is that everything that you have now and everything that you acquire between now and when you die, you transfer to the trustee of the trust, which the trustee is usually the trustor. So my client, it creates the trust, they're the trustor, they name themselves as trustee, and they're also the beneficiary. So they are filling all three roles initially until, later down the line, if they become incapacitated or something else, then a successor trustee would come into place. So this type of trust is funded with the assets of the trustor. So bank accounts can be retitled in the name of the trust. Real estate can be transferred to the trust with a deed. Investment accounts can be transferred into the name of the trust. Vehicles, um, pretty much any asset can be owned by the trust. And some assets have paperwork or deeds that need to be done, like real estate and vehicles. Bank accounts, other things like personal property, jewelry, furniture, stuff like that. It's just an assignment, a written statement that your personal property is now owned by the trustee of the trust. Um, and then some assets can also be uh, set up in a way that the individual still owns it for the rest of their lifetime, but it transfers automatically into the trust when they pass away. So you could have a beneficiary designation on a financial account that, during your life, the account is your account, but upon your death, the beneficiary designation for the account is, the successor trustee of the revocable living trust. So the important thing with a revocable living trust is to make sure that you get all of your assets into the trust. Because if you don't, then you still have to do a probate to put assets into the trust. So if someone had um, one financial account that they didn't have any beneficiary designations on, then that becomes an asset of their estate. And then you have to do a probate to move that asset from their estate to the trust, which the purposes of a revocable living trust, the very first one on the list is to avoid probate. You only avoid probate if you successfully have all of your assets either in your trust during your lifetime or have a mechanism where they transfer into the trust upon your death. I've done a few probates for people who had revocable living trusts and had, some account, some check that was big enough that was written to them. Um, One, wrongful death lawsuit, you can't exactly transfer that into your trust, so that ends up getting carried out in the probate. Um, and it's unfortunate when we have to do a probate when the client has done the estate planning. They've been proactive and invested in their estate planning, hoping to avoid probate, and then sometimes the probate still needs to be done to get the last bits and pieces put into the trust. And then the other purposes of a revocable living trust are really the same as a testamentary trust. I mean, you can set up a trust for minor children. You can set up those two examples of a trust for a surviving spouse, special needs trust, and then more control over assets after death. Um, I think the two reasons that really make me recommend a revocable living trust to a client is if they have real estate outside of the state of Washington. Part of the reason there is that you get the value of avoiding probate in two states. Um, Now, they could transfer the out-of-state real estate into an LLC or do some other mechanism to avoid a probate in that other state, but you have to do a probate in the state where you live and any state that you own real estate. So avoiding probate in two or more states really starts to pencil out on the cost of a revocable living trust um, over just relying on a will as your primary estate planning document. And then the other is when someone wants to have more control over the assets after their death. because they really can uh, fine tune those rules. That the trustee can only distribute money for education or for um, buying a house or paying for a mortgage or something like that. So you can really fine tune what the trustee can do, and having that in place while you're alive makes it easier to transition once you pass away because you've already talked to the successor trustee. They know what they're supposed to do. And then, there's a day that they become the successor trustee and they step in, and there's some continuity there because it was happening the same as before and after you passed away or became incapacitated. So it makes that transition a little bit easier when you know you're going to be using it for a tool like that. Like for minor children, most clients that have minor children are probably going to avoid this problem because they'll live long enough that their children will be adults before they pass away. So, you know, I don't think it would be worth doing a revocable living trust only for the purpose of having a trust for minors, because there's a good chance that you will never have a trust for minors because you will live long enough to avoid that. But we try to plan for as many different possible fact patterns as we can. Um, but where it's a low probability chance, maybe a will with a testamentary trust provision would be adequate to meet that need. There's some other reasons that it might be good to go straight to the revocable living trust. I guess the one point about avoiding a probate. In Washington state, probates are not particularly expensive or time consuming. Some other states, the fees for probates and what a personal representative can pay themselves and do stuff are based on the value of the assets in the estate. So, in California, for example, a probate would be significantly more expensive than it would be in Washington state. So if I had a client who anticipated moving to California, I would probably say, hey, let's just go straight to the revocable living trust because you're going to want it once you're in California. Well, I hope that helped understand a little bit about the difference between trusts that are created through a will and trusts that are created while you're living. One other kind of significant difference is that if you create a trust while you're alive, so revocable living trust or some other trust that you create while you're alive, you have to manage that throughout the rest of your life. So you have to make sure that, if you buy a house, you after closing, you turn around and transfer it to the trust. And if you buy a car, you have it owned by the trust and accounts and all of those things. So, there's some um, maintenance might not be the right word, but there's some, thought that has to go into it to make sure that the trust does what you expect it to do. With a testamentary trust, you put the provisions in your will, and then there's nothing that you have to do until the personal representative, uses your will through a probate to create that trust. So there's, definitely some simplicity to using a testamentary trust for the types of things that you might need a trust for. So if that tool works, then it's a good tool because it doesn't require as much work to maintain as having a revocable living trust. But each client is different, different priorities, different experiences. I mean, I've had clients who at all cost want to avoid a probate. They usually just got done doing one. Um, and they're willing to do a revocable living trust, even though I might not think it's necessary. Um, but for them, their most important goal is to avoid a probate, and that's fine. If that's the client's goal, then we meet that goal. But sometimes there's easier ways to still achieve some of those goals. So if you have any questions about trusts or estate planning, power of attorney, healthcare directives, different types of trusts, feel free to give me a call. The information's there on the screen, or shoot me an email. And I look forward to talking to you and hearing what your goals in estate planning are and seeing how our tools can help you meet those goals. Thank you.